Well, good morning or good afternoon, everyone. Thank you for joining me once again. You know who I am, I hope. I'm Lior Samfiru, the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. And as the employment lawyer, what do? Well, once a week, I log on right here on YouTube, on Facebook, on LinkedIn to do a live Q&A session. And that's what I'm doing today. I'm here live answering your questions. I'm here at your service to tell you what you need to know about employment law. So again, about me, for those just joining us today for the first time, I'm Lior Samfiru, one of the founding partners of Samfiru Tumarkin LLP. We're the largest employment law firm in the country. We operate in Ontario, in BC, and in Alberta. And if you're in one of those provinces and you have a workplace question, if you have a workplace problem, if your boss did something, if you are losing a job, lost your job, whatever the issue is, you're in the right place to get that problem solved. How do you do that? Very easy. You see a box on your screen, you type in the question, you press enter, and you're done. Your job for the day is done. Then it's on me to read it and answer it. It's as simple as that. So we're live right now for that purpose. I want to take as many questions as I can today. I want to make sure that I'm answering everything. Questions are already coming in, so ask yours and I will get to it, I promise. Now, for those that want additional information about employment law, or they want to connect with me and my team after the session through after social media, easy to do. You just go to employmentlord.ca. You see that address on the screen right now, employmentlawyer.ca. And when you go there, number one, you can read a lot about employment law. That's great. The other thing you can do, of course, is you can get my contact information, phone number, email address, forms if you prefer. It's all there for you and for your benefit. So take advantage of that. But that's for later. For the next 30 minutes, I'm right here, not going anywhere, really just for you, wanting to answer your questions about employment law. So what kind of questions? Severance questions if you lost your job. Do you want to know if what your employer offered you is fair? Ask. Spoiler alert, it's probably not fair. If you have a question about your boss being or not treating you properly, bullying, harassment, a poisoned work environment, ask that. It's a constructive dismissal. Maybe your job has changed, your compensation, hours of work. Maybe you feel you've been discriminated against. I can keep going. I think you get the idea. If it has to do something with your work, I'm here answering those questions right now, so take advantage of it. I'm going to start answering questions right now. So ask yours as well, please. Guys, I'm Lior Samfiru, the employment lawyer, answering employment law questions. All right, let's get going. First question of the day, and thank you for that on YouTube from JBK. If you've been working for a company for 2 years straight, but they only have you as a supply at a daycare, would I be entitled to health benefits from my employer? So the law does not impose an obligation on an employer to provide health benefits. So the law doesn't, there's no legal requirement for the employer to provide benefits. So an employer can decide if they're going to provide benefits or who they're going to provide benefits to. I'm going to be ridiculous here, but an employer can say, I'm only going to provide benefits to people whose name starts with the letter G. That's stupid, of course. No employer is going to do that, but they could, because they can decide how to provide benefits. So to get back to your question, your employer can decide who they're going to give benefits to. Okay, so people that work those hours or these hours, that's up to your employer. The law doesn't get involved in that. It stays away from that. Now, of course, if you lose your job, you're going to be entitled to severance. What they call you and how they characterize you internally, it has no effect on your severance. So keep that in mind if that ever comes to pass. But certainly with respect to benefits, company gets to decide who to pay it, how to pay it, and that's how that works. JBK, hopefully that helps. Thank you for that question. All right. Next question from Bev on YouTube. Are severances awarded yet for non-unionized long-term care employees who are still on unpaid leave for refusing the vaccine? Absolutely. We've resolved dozens and dozens, if not hundreds of those cases, and are resolving them every day. So absolutely. All you have to do, if you or someone that you know is on a leave because of the vaccine status, give us a call. All right. It's as simple as that. Let's get going to get you that severance. It's not complicated. Companies, frankly, want to get these resolved and done with. So yes, you absolutely can get severance in those situations. We do this daily, multiple times a day. So Bev, if it's for you or for someone that you know, easy to do, to contact me, right? That's how you do it. You just go to employmentlawyer.ca. Again, you see that address, employmentlawyer.ca. Phone number is there. You can call, email if you prefer. You can send an email. Form if you want to fill out a form, and we'll call you. It's all there, employmentlawyer.ca. Great question, Bev, because a lot of people are still wondering about that. So thank you. Hey, if you're joining us right now, you see how easy it is. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I just answered the first couple questions. Very easy, takes seconds, so you can have your questions answered right now. If you've always wondered something, you've always thought, well, I think I know, but I'm not sure. No point guessing, right? Just ask the question, and I'll answer it, and I'll tell you what you need to know. Now, in between your questions are priority, but in between those questions, I wanted to answer some questions that I get asked often. Usually I get questions that start with, hey, Lior, can my employer do this? Are they allowed to do what they're doing? So I've picked a few kind of common questions that I get, and I'm going to answer them now. Again, but this is in between your questions. You still can and should ask me your question. So one of those questions is, can my employer make my shifts longer or have me start earlier? So an employer may say, well, we've made some changes. We want you to work different hours, longer hours, or to start later or start earlier. Can they do that? Well, usually the answer is no, they can't. Now, an employer can do that if it's a minor change. So instead of having you start at 9, could they say 8:30? Yeah, they can kind of get away with it because it's considered a minor change. But could they say instead of 9 o'clock, you start at 7? No, that would be too big a deal at that point. So they can't generally make significant change to your shift, whether it's more hours, less hours, obviously, because that means less pay, changing the hours of work, having you work weekends. A lot of people come and say, well, I usually work weekdays. Now my company says they want me to work rotating shifts or every other weekend. Can they do that? No, they can't. That's a significant change to the terms of employment. Again, we're of course only talking non-union employees, okay, non-union. We're not talking about union employees at all here. But for non-union employees, no, they can't do that. If they do that, that may give you a right to treat this situation as a constructive dismissal. So you can't physically stop your employer. You can't physically restrain them from changing your shift. But what you can do is, if they're going to do it anyway, is you can consider your employment as being terminated and get some severance and get your full severance. So that severance can be as much as 2 years pay. All right, so that's one question that I kind of get asked often, but your question is live right now is my priority. Again, ask your question. I'm Lior Samfiru, the employment lawyer, answering questions. So next question comes from Rachel. Can your employer require you to give 3 months notice? It seems excessive. Well, first of all, if you signed an employment agreement that says, if I leave, I'm going to give 3 months notice, well, then that's your obligation because you've agreed to it. It's a contract. But if you didn't, and the company says, hey, heads up, I want you to give 3 months notice, no, they can't do that. That is excessive. The law requires you to give reasonable notice. Now, if you were working in a very specialized position, very important position, and if you left, it would be a disaster for your company, well, maybe the law would say that 3 months is reasonable. That would be extremely unlikely. Usually what the law would consider to be reasonable is 2, maybe 3 weeks, no more than that, unless you're in a very, very, very unique situation. But at the end of the day, you have to pay attention to the employment agreement that you signed, right? If it says I'm going to give 6 weeks or 2 months or 3 months notice, well, that's what you've agreed to, and that's what your legal obligation is. All right, so good question, Rachel. Thank you for that. Next question is from Gills Green Talon. This is from YouTube. My employer is forcing me to work when I reach my limit, resulting in my spine, and they did it twice in the past. My coverage to WSIB with very minimum severance. I'm not sure exactly what you're saying. Can I still sue them, and what laws? I'm not sure what do you mean. In the past, my coverage with WSIB with minimum severance. So have they let you go? If they let you go, you have 2 years to pursue your severance. So if they let you go 2 years ago or less, you can absolutely take legal action and pursue your severance. If they let you go because of your medical condition, because of your injury, that's illegal. That's a human rights violation, right? You cannot be let go because you have a serious medical condition, a disability, an injury. If you are, again, that's illegal. So that could be potentially that avenue to pursue as well. So yes, if in fact your employer did something to your job, maybe if you have limitations, by the way, you need modified duties and they won't accommodate you. Say, well, no, we're not going to accommodate you. Come back when you're healthy. Well, that's illegal. An employer has a duty to accommodate. It's a very important and very strict duty under our human rights laws. So again, and you would have 2 years. Now, the human rights limitations may be 1 year, but certainly on the severance front, it's 2 years. So if that's you, you need to contact me as soon as possible. Again, you do that, see that address on the screen, employmentlawyer.ca. Again, employmentlawyer.ca. So Bev Elliott has a follow-up. Bev was asking about long-term care workers getting severance if they are off work because of their vaccine status. And Bev asks, must we maintain our license/registration as a healthcare provider in order to win the severance? No, absolutely not. It has nothing to do with it. One thing, though, I want you to note, Bev, is this. Everything I said only applies if you're not a union member, if your job was not unionized. If your job was unionized, you have to talk to your union. Whether they help you or not, I don't know. But nothing that I say here today, nothing that I really ever say applies to unionized employees. Only applies to non-union employees, okay? But if that's you, Bev, call me ASAP. Again, to do that, just go to employmentlawyer.ca. Those joining us, you have some time to ask questions. I'm Lior Samfiru, the employment lawyer, and what I've been doing since I logged in here about 10 minutes ago is I've been answering questions. I want to answer yours as well. And don't wait till the end. I say this every week, and it's every week it happens. People wait till the end of the session to ask a question, and I don't get to it. You have time now. You can take your time to type, press enter, and I'll see it, and I'll read it, and I'll answer it. So don't wait. Just do it now. All right, next question today on YouTube from Joe. If someone is forced off on medical leave due to a toxic environment and has suffered retaliation during that time after launching a harassment complaint, is there something that can be done? This employee is over 60 and has worked over 30 years with this company. So absolutely, there's a list of things that you can do. The key here is, can the harassment or the retaliation be proven? Can it be proven? Because remember, the company or the person that's doing the harassment or the retaliation is not going to admit it. They're not going to say, yeah, we did it, right? They're going to say, no, we never did it. So the question always becomes, how do we prove it? Is there a witness? Is there something in writing? Is there a recording? If there's the ability to prove it, easy. That could be, number one, constructive dismissal. It could be a human rights violation. It could be a reprisal, which is a breach of the employment standards legislation. So there's a number of things here, and you would have tons and tons and tons of leverage to resolve this on great terms. But again, if it's just someone's word against someone else's, it gets a bit more complicated, right? Because someone can say, here's all these things they did to me. The other person says, we didn't, prove it. So that's the question. If it's in writing, I just saw you post it in writing, easy. Probably one of the easiest cases when we have that proof. So I'm assuming you're writing about someone else, Joe. Have them contact me today, even, okay? To contact me, employmentlawyer.ca. Again, employmentlawyer.ca. You'll get the phone number, you get the email address. Everything is right there. So take advantage of that, and employmentlawyer.ca. All right. Let's see. Darlene on Facebook. Hey, we got a Facebook question. Darlene asks, can an employer get you to sign a new contract after 10 years when changing shifts? Well, it's not can they do that, is should you agree to it? And the answer is absolutely not. Absolutely not. You should always be very concerned when your employer all of a sudden wants you to sign a new employment contract. There's no reason why they would need that. And well, the reason why they need it is because it provides them with better terms. For example, I can almost guarantee you that the contract that they want you to sign would limit your future severance. So if 2 years down the road, as an example, they want to let you go, they'll have to only pay you a tiny fraction of what they would otherwise pay you. It could be the difference between getting 12 months severance and getting 8 weeks severance. Massive. It can also give them the power to put you on a temporary layoff, to reduce your pay, to change your hours. Bad idea. So it's not something you want to sign. Now, probably the best thing you can do is, if you've been asked to sign that document, send me a copy, right? Let me see what it says. I'll read it and I'll tell you, is it good, is it not? But I'm telling you right now, be very, very concerned about it. Extremely concerned. All right. So, Darlene, hopefully that answers the question. Don't sign it. Rick says, I'm in California. Does this apply? No, nothing that I say applies in California or in the US generally. Ontario, British Columbia, or Alberta. That's it. So Joe, who was asking a question about workplace harassment and reprisal, says, there's another person involved in this as well that has a bigger issue that was actually terminated. You know what to do then. Man, oh man, you have to do this. Have them contact me right away, okay? I can't help them. I can't actually do anything for them and get them the compensation through social media, right? I need to actually speak to them, get involved, and roll up my sleeves, get to work. To do that, easy, easy, easy. You know what to do. Employmentlord.ca. That's your gateway for everything, okay? So have them contact me as soon as possible through employmentlawyer.ca, and let's get to work, all right? Great questions today, guys. Some of the best questions I remember. So you have time as well to ask me, the employment lawyer, Lior Samfiru, questions about your workplace rights. So take advantage, ask questions right now. Give me that chance to help you like I've been doing for the past 15, 20 minutes. All right. My regular viewer, N. Stinson, hello, on YouTube. Is it cause to terminate federally regulated employees who has not taken mandatory company training? Well, it's a question of when was that training introduced? Is it introduced when someone is hired, or if the company says, now we've been working here for a while and we need this new training to be done. Now, if it's minor training, you have to spend a couple of hours maybe doing it. Yeah, it would be reasonable for them to expect that. And if you don't do it and you can't do your job because of it now anymore, that could be a problem. On the other hand, if it's significant training, well, now you have to go attend weekends and it's a big deal. No, they can't impose that. That could be a constructive dismissal. So the devil's in the details here. When was this training introduced? Why was it introduced? For example, in some situation, the government imposes regulations on certain professions and says, well, to continue in this profession, you have to have this certification. So the employer may say, well, hey, we have no choice here. The government's telling us we have to, in which case there's no choice. So there's a lot of things here to consider. So if this is a specific person that you're asking about, probably best to have them contact me so I can get this information and advise them properly. And of course, employmentlawyer.ca is the way to do that. All right, let's see here. So next question Joe asks, do we ask for you directly when they contact? No, you don't need to. We have a whole team here. So whether it's me or one of my partners and colleagues, you're in great hands, okay? We have the best team in this country dealing with these issues. Just call us through that number, and the first person that's available, the best person that's available, whether it's me or one of my colleagues, will help you right away, okay? So just go to employmentlawyer.ca. Let's see. So Gil's Green Talon says, let's see, last year in August, they forced me to overwork. Until now, it's still in bad condition in my spine. So I'm not sure what you want to sue them for exactly. If you're still working, if they're forcing you to do something that you can't do, all you have to do is get a doctor's note saying that you can't. So you need a doctor's note. They can't refuse that. If they refuse your doctor's note, then you call me, okay? So you can't sue them for your injuries, right? WSIB, that's your only recourse. If you're injured at work, even if it's your employer's fault, you can't sue your employer for the injuries. You can sue your employer if they owe you severance and they don't pay you. You can sue your employer if they discriminate against you and don't comply with human rights legislation, but not for your actual physical injuries if you're injured at work. You have to go through the workers' compensation system. All right, next question just came in on YouTube from Kelvin. Hi, Lior, I'm in Ontario, Canada. If someone signs a termination letter after being laid off, can they still go to a lawyer to negotiate severance? They only offer 2 weeks. Generally, the answer is no. So essentially what happens is once you signed that severance, there's now a contract in place. They offered you something, you accepted. That offer and acceptance creates a contract. So you can't get out of it, just like they couldn't get out of it. So you don't do that ever, 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 okay? You say you were offered 2 weeks. I can tell you, without even knowing anything about your situation, that you would have been owed much more than that. Even people that have worked for a short period of time, usually severance starts at 3 months. Starts at 3 months. Doesn't end at 3 months, starts. So 2 weeks is not good, terrible. But if you've accepted it, it's a problem. And no, generally you can't get out of it. So that's why you don't sign. You don't sign. Every single week I get people contact me when they say, well, I just realized that I was owed another $50,000 in severance, but I already signed and accepted. Can you help me? And I always have to say, no, unfortunately, I can't, right? Because you've signed it. And you say, what if it was signed under pressure? Well, the pressure would have to be the threat of illegal action. So, for example, if you don't sign, we'll hurt you. If you don't sign, we won't pay you your wages. We owe you salary, but we're not going to pay it. If they threaten to do something illegal, unless you signed, it's not considered. Every situation when you let go, there's pressure. You have to sign this by 5 o'clock or we're not going to pay it. That's what happens in every severance. So that's why you don't sign. Now, this is a good time to tell you about how you can find out always and quickly and easily how much severance you are owed. You don't even need to call me for that. You don't even need to go to employmentlord.ca. You can grab your smartphone, you grab your tablet, and you can use our severance calculator. All you do is you go to pocketemploymentlawyer.ca, pocketemploymentlawyer.ca, and right there you will see our severance calculator tool. It's so easy to use. It takes seconds. It's completely free. It's completely anonymous, and it allows you to find out how much severance you're owed. Is it 2 weeks? No, it's not. Is it 3 months? Is it 24 months? Something else. Easy to use. Over 2 million people across Canada have used it already. Over 2 million. We're probably closing in on 3 at some point. So that's why it's always the first place you go to. If you lost your job and you're staring at that severance letter, if you're thinking that tomorrow you're losing your job, if you're worried about losing your job, or maybe you're just curious and you want to know right now, hey, what is my severance actually worth? What would I get? I don't know about you. I'd like to know that information, right? So all you do is you go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Use our severance calculator tool there and find out. Arm yourself with that information. And of course, if you want to, you can contact me directly from that severance calculator. There's a green button there at the end. You can press that if you want to contact me directly, only if you want. So that's what you do for Kelvin or anyone else. Very important. I hate giving bad news, such as I can't help you because you signed that severance letter. I have to do that every week, unfortunately. But now, if you're watching us, you know better. And I want you to spread the word. I want you to tell your friends and your family and have them tell their friends and their family that if someone loses their job, they never sign. No exceptions. Okay? They never sign. Because in almost every case, you're owed a lot more than what you've been offered. Still have some time to ask questions, and I want you to do that. I want to still answer questions. But as promised, actually, question just came in right now. I'm going to answer it. But please, guys, I know what's going to happen. You'll see that I'm right. In the last minute, I'll have like 3 questions or 4 questions come in. I'm not going to be able to answer them. You still have time. You don't have to rush. I don't have to rush. Ask your question right now. Chantel has the next question for us. Can you be demoted as a result of poor performance? I tried to refute the accusations of mistakes and errors, but was not listened to. So, no, generally speaking, you cannot be demoted, even if the company says your performance is not good. If they think you can't do your job, they can let you go and pay you your severance. It is what it is, if they're not happy with the performance. Or they can performance manage you. They can help you and provide you support and put you on a performance improvement plan if needed. But a demotion generally results in a constructive dismissal. You don't get demoted. The company doesn't just have, that unilateral right to demote you. If they do, you can either accept the demotion and continue working. Of course, you can accept it if that's what you decide to do. or you can choose to treat that demotion as a constructive dismissal. So employer, by demoting me, you're not allowed to, but by demoting me, I'm now going to leave. I'm going to treat this as if you've terminated me. Now you must pay me my full severance. So that's what a constructive dismissal is. So no, you can't just be fired for that. You can't just be demoted. But it is always a good idea, by the way. I'm going to segue a bit here, but if your employer has problems with your performance, if they criticize your performance, they put you on a performance improvement plan, or they give you a negative performance review, if you don't agree with it, if you don't think it's accurate, if you don't think it's complete, you say so, and you say so in writing, and you explain why. Okay, employer, here's why I don't agree with what you've said. Here's what you need to know. Here's some other facts that you weren't aware of. Whatever it is, you put that in writing. Now, you're going to be professional about it. You're going to be respectful about it. You're not going to be rude or disrespectful. You're going to do it right. But you're going to put that in writing. And by doing that, you're going to protect your job. You're going to make it much more difficult even for the company to let you go for cause, to try to avoid paying you severance. So you have to do that. Always respond. Your lack of response, your silence is exactly the same as if you said, yeah, I agree. I was wrong. You were right. Okay. So you don't want to do that unless you actually, in fact, agree with it. Okay. So that's something very important to understand. Now, another common question that I often get is, can my employer make me, this is tied to that, can they make me sign a performance improvement plan? So here's where people sometimes get worried. I don't agree with this performance improvement plan and my employer wants me to sign it. Read it carefully though. Generally, what they want you to sign is simply to acknowledge that you've received a copy of it. Not that you agree with it, not that it's correct, just that you've received it. And it's absolutely fine to sign acknowledging that you've received it. You're not going to say, no, what do you mean? I didn't get it. You're not going to do that, right? So it's okay to sign saying that you've received it. What's not okay is if it says by signing here, you agree that this is all correct. Well, you can't sign that unless you agree with it. Then you don't sign. But generally, that's not what it does. It simply says, sign here to acknowledge receipt of this performance improvement plan. It's perfectly fine to sign, no issue. Okay? Hopefully that makes sense. Another question that I get asked when someone wants to know if their employer can do something is this. Is that my employer says that it's struggling financially. Can they cut my pay because of it? So this happens. It's happened a lot during COVID. Company says, listen, we're struggling financially. We're not lying to you. It's true. You can even look at our books. We're struggling financially, so we have to cut your pay. Well, can they do that? No. Even if they're truly struggling financially, even if there's a legitimate business reason as to why they want to cut your pay, an employer doesn't have that right. Okay? An employer doesn't have that right. That can result in a constructive dismissal. Simple as that. Your employer, now, they can do a minor cut, but anything kind of over 10% or so, it results in a constructive dismissal. So remember that. It's not just about whether or not the company has a good reason. Even if they do, constructive dismissal should come to mind. Let's see. Next question. Probably the last question for the day from M. Ellie. Are EI benefits being paid yet to healthcare workers who lost their jobs because of vaccine status? I was denied before. Well, it's been all over the place. There have been some situations where EIs approved it, other situations where they haven't. There recently was a court decision agreeing with EI's denial, so it's really all over the place. Now, the key here, if you're not part of it, if you're a unionized employee, nothing you can do other than have the union try to help you. But if you're a non-union employee, we can deal with your employer to get them to issue you a new record of employment that then you can use to apply and get EI. So very important for non-union employees to remember that. Of course, again, that only applies to non-union employees. So thanks for that, Emily. And that's the time that we have for today. And I know as soon as I say that, there are going to be more questions coming, but that's the time we have for today. If you haven't gotten your question answered, or if you want to follow up with me like I've asked you to do, you're going to go to employmentlawyer.ca. You can contact me through there, okay? Contact me through employmentlawyer.ca, and we can continue the conversation through phone, through email, any way that you want. It's important that you do that. Don't wait till I'm back here next week. Contact me today if you need to, all right? employmentlawyer.ca. I'm Lior Samfiru, the Employment Lawyer. Always a pleasure to be here with you guys. I always enjoy it. Thank you for the opportunity to talk to you and to answer your questions. I'll be back next week, but for now, the place you go to is employmentlawyer.ca. Thank you, everyone. Have a great day, and we'll talk soon.